Hello, I'm Dan Marr from Hamblett, Kerrigan, and today I'm going to be talking about boundary line disputes between the neighbors in New Hampshire. I've tried a variety of these cases over my 35 plus years of practice here in New Hampshire, and I know they can be very emotional, very frustrating because they're dealing with your neighbor, and we'll be talking about the variety of circumstances on which the boundary line disputes occur. The core issue that I'm going to start off with this short blog about is the survey matters, but it's not conclusive. Surveys are done by one neighbor and they show the title record of the property. For one, you want to maybe have another surveyor look at that, because I've had cases where the surveyors have a disagreement as to where the record title is. The record title being what the deeds say, looking at the plans on the property, looking back at the track of the record, going back to the original subdivision of the property, and determining really where the line is in the field. There might be pens that were removed. There might have been an old oak tree that is now rotted away and no one knows where it is. So there might be assumptions that are made by the surveyor that the other surveyor may be able to challenge. So there might be an issue as to the record title. So just because one surveyor says that this is where the record title is, you may decide that it's worthwhile having another surveyor looking at that. I will tell you that surveyors, by their own oath, are not supposed to be adversaries to each other. They're supposed to be together working to try to find out the true record title to the property, because there should be one location where that boundary is, and they should be working collaboratively on that, but still sometimes somebody can get it wrong and they can make wrong assumptions. And there are a variety of rules that are applied in surveying that need to be applied in the field to determine what the proper record title is. That being said, there's a variety of other issues that determine what the boundary is. There's something called adverse possession. There's boundary by agreement. There's boundary by estoppel. And we'll talk about those. I've had those claims that I've litigated quite a bit. There's actually, in lakes, there's a whole body of law as to accretion when there's a flow, the same with oceans. When there's a flow that comes about and it actually creates a beach, what happens? Who owns that beach when it flows from one person's property to the other? There's a rule on that, and I've dealt with that up in Bristol, up in Newfound Lake before. So there's a variety of issues that you deal with in the boundary line disputes. But adverse possession is one of the ones you hear a lot. That's 20 years of continuous, notorious adverse possession, basically letting the other side know that for 20 years you're claiming this property is yours. The other side may think that the property is yours, and if you both think that the property is yours, that's just more of consistence with that. There's also called boundary by acquiescence, where both sides think that that's where the boundary was, and even if they didn't have a discussion about where the boundary was, they thought that. I had a case that when my client was mowing the lawn of this particular property, the other side thought that they were mowing that person's lawn. So when Jack was mowing the lawn of Jill, Jill thought that Jack was mowing Jack's property. So later on, when Jill sold her property to somebody else, and the new person went and got a survey and said, "Wait a minute, Jack, you've been mowing my property all these years." I went to court and I tried the case. I went up to the Supreme Court too, and I was successful in this. Was the court agreed that, well, when Jack was mowing that lawn, Jill for 20 years thought he was mowing his own lawn. So it was obviously open and notorious and sufficient actions on his part to prove that he was actually trying to mow his lawn versus Jill's lawn. The actual mowing of a lawn itself is not enough. If Jill thought when he was mowing, he was just mowing my property, that's not enough. If when Jill saw Jack mowing Jill's property, Jill thought he was just mowing Jill's property and he wasn't claiming ownership to that for the 20 years, then that won't be enough for adverse possession. That happens a lot with just even the loops around of somebody with a sit-down mower, or somebody might decide that they don't like the fact that you're not mowing the back of your field, so they mow it for you without even asking for permission for it. That's not going to generally be enough for adverse possession. Certainly putting up a fence, blocking your ability to use the property, that would be very clear. And certain other actions like a driveway or the like can be adverse possession. a pool. I've seen situations where somebody's garage or deck is on the other person's property. Well, if that's been there for 20 years, or even a septic system, that might be enough for adverse possession for the 20 years. But you have to have 20 years of uninterrupted adverse possession that's contrary to somebody's ownership. What happens sometimes in situations where the neighbors within the 20 years have a discussion about the boundary, and one of the neighbors says, well, you can use it for now. Let's decide. That gives permission. That blows the 20 years. You don't have adverse possession during that 20-year period. There's an acknowledgement by the other person that you're using the property, and they say that you can do that temporarily. When you're dealing with the pools and the other structures on the property, it's much more at stake than there is about somebody saying that, well, I don't want to lose some of my front yard. So it's a question of whether you want to litigate those questions. I see a lot of this on waterfront property where the waterfront is important enough to litigate. The boundary by acquiescence, sometimes people won't know where the boundary is, and they both kind of, they only have a formal agreement, but they both acknowledge that that's where they think the property boundary is, and they just leave it that way. Boundary by agreement is actually an agreement by somebody that says this is where the boundary is, and you don't need 20 years for that. So if Jack and Jill, when they first bought the property, or when Jack bought the property from John before, and Jill still lives there, Jill comes over and says, this is where the property line is, and she explains it to him, and he says, okay. And then for like 2 or 3 years, that's where the property line is, and then Jill sells her property to Sam, and then Sam is dealing with Jack in this, and Sam's saying, well, look, I got a survey that says that's not the property line that Jill said. Too bad. Sam stuck with what Jill said because she was the title owner, and it was title by agreement between the parties. I've made that argument. I've been successful in that argument before in court. Boundary by agreement. Boundary by estoppel is a situation where somebody actually makes you rely on that. Perhaps when you're buying the property, they put a fence up as to where the beachfront of your property and their property is, and they show that so that you think that you have that portion of the beach, and then they do a survey or something, and they turn around and say, no, you don't have any of the beach of the property, or you don't have your frontage that you thought you had, or maybe even your backyard of your residential lot that you don't have. So in that situation, there can be boundary by estoppel, and that's proven in court as well. This can equally apply to both residential and commercial properties. I see it mostly applying in the residential properties where people are having these fights. It certainly can make a difference in setback requirements for structures. It can make a difference as to certainly when a boundary line goes through somebody else's structure. But you need to litigate these cases if you're claiming that the record title is not the actual title. You have to go to court and prove that, and I've dealt with those cases in the Superior Court, and we've tried those cases. Generally, you try them to the judge. Thank you. If you have questions in regards to this or other topics in regards to the law, you can contact our firm at onewordnaturalaw.com at our website, or call us at 603-883-5501.